You hear that? That's the sound of the train leaving the station and possibly going all the way to the U.S. Supreme Court. Today we're talking about AR-15 bans, so-called assault weapon bans, normal capacity magazine bans, or as the victim disarmament enthusiasts like to call them, high capacity magazines, and a whole lot more. So strap yourself in, grab a tail gunner, bucko, because we're going on a bumpy ride. We're going to go visit the 7th Circuit Court of Appeals in Chicago. We're talking Bevis v. Naperville. Guys, let's get into it. So the 7th Circuit ends up ignoring U.S. Supreme Court precedent and decisions from multiple cases, and instead they basically invent their own test to, surprise, surprise, arrive at the decision and the conclusion that seemingly they wanted all along. Now, I will explain this in kind of a speed read. I'm going to try a different way of doing it where I'm going to give you kind of the theme of the case and keep tying things to it as opposed to giving all the details. And as a result, I'll be skipping over a lot of BS in the 95-page decision that you will find linked in the description box below. I want to let you know about one of our channel sponsors. This will just take a quick hit. Sometimes when I run into people, particularly at conventions or shows, they want to know, Tom, how did you get into firearms? Because I did not grow up in a household that had firearms. We never talked about firearms. My father passed when I was young, just myself, my mom, raised by a single mom. She wasn't anti-gun. She's from New York City, even though I'm from the Midwest, born and raised. How the heck did I get into firearms? I got into firearms through collecting military surplus firearms in college and beyond and getting involved many years ago in IPSC and IDPA. And that's what makes this sponsor kind of cool to me. Collectors Firearms regularly has over 12,000 guns and 500 swords in stock. So for you sword boys out there, they got you covered. They deal in all types of firearms, both new and used, as well as modern guns to antique guns, and they have guns from every price point, starting out at around $100 all the way to over $500,000. You can browse thousands of modern and antique firearms to find your next firearm or memorabilia for your collection. They have expert staff on call 7 days a week to answer any questions that you may have. You name it, they say they've got it. I tell you, I've browsed their website, which is pretty cool if you're into military surplus stuff like I am. They've got a lot. So whether you're a competitive shooter, a plinker, or collector, Collectors Firearms has the right products for you to check them out. As they say, the best damn gun shop in the world. Be sure to check them out. Linked to their Facebook page. Thank you to YouTube Rules and Community Guidelines in the description box below. But also, of course, if you just Google Collectors Firearms, you'll find their website pretty quickly. All right, we're going to try something totally different and new. Here's basically what the 95-page decision does. The 7th Circuit Court of Appeals cites to the 7th Circuit Court of Appeals from an earlier case called Friedman. Friedman basically predates Brune. That was the 2022 decision, which developed the historical tradition analysis and all that kind of stuff and expanded the common use argument. But the 7th Circuit Friedman decision, they basically invented their own test that created a spectrum of firearms. And you've got military-grade firearms, their words, not mine, military-grade firearms at one end of the spectrum, presumably like civilian-only weapons, whatever the heck that means, at the other end of the spectrum, and then you got folks kind of in the middle. What the 7th Circuit did, and what they expanded on in this case, is they said this. Basically, military-grade firearms are not protected by the Second Amendment. Why? Again, don't shoot the messenger. Because what they did is they wanted to look at, okay, if you're a militiaman and you get the muster call, what bearable arms are you turning up with? And they decided that, you know what, you would not have whatever constitutes military-grade firearms. You would have civilian-grade firearms. I realize how absolutely insane this all is, considering the fact that, you know, the civilian-grade firearms were the military-grade firearms back at the Founding Fathers. So I appreciate all this. I'm trying to give you the Chicago logic, so just bear with me, okay? So that's basically it, is they've created a class of firearms that they're calling military grade. They cite as an example of the existence of this class of firearm the fact that, in their view, machine guns, suppressors, and so forth are all absolutely illegal for civilians to own, which flies in the face of experience, logic, and Google, because among many other things, there's almost 200,000. I think last I checked, there's 175,000 civilian transferable machine guns in citizen hands today across the United States. And by the way, do you know how many of those have ever been involved in the commission of a serious crime? 0. Zero to my knowledge. So there you go. So what they do in this decision, linked in the description box below, is they say this. You know what? We don't really see a difference between M16s, which are these military-grade weapons, machine guns, and AR-15s. They're operatively basically the same thing, or they're close enough to be indistinguishable. For God's sake, people, I'm not the one saying this, okay? But that's what they do. That's what they say in the decision. And as a result, they say that we can ban, and states and governments can ban AR-15s and other so-called assault weapons without offending the Second Amendment. There you go. You want to cut through 95 pages? There you go. That's cutting through 95 pages. So how do they do away with the fact that we've got Heller, Catano, Brune, all these U.S. Supreme Court decisions that talk about common ordinary use and all this other kind of stuff? Keep in mind the Catano U.S. Supreme Court decision in 2016 upheld the existence of tasers as being completely lawful for citizens to own, finding that they were in common ordinary use, even though there was a few 100,000 of them in common ordinary use. Kind of comparable to the number of machine guns, but, you know, neither here or there. I'll also add in the same paragraph here the fact that both U.S. Supreme Court Justice Clarence Thomas, in the dissent that denied a writ of certiorari in a particular case, specifically went out of the way to say that AR-15s, semi-automatic AR-15s, his words again, are absolutely in common ordinary use, citing that there was only a handful of million of them at the time, as well as the fact that in another Heller case that followed the first Heller Supreme Court case by a handful of years, this one made it to the D.C. Circuit Court of Appeals. That circuit court ruled that AR-15s are in common ordinary use, with only 1.6 million manufactured between the 80s, 90s, and all the way up to 2011. Now, we know that today, if 1.6 million is good back in 2011, if a handful of millions are good more recently in the U.S. Supreme Court, Justice Thomas, as well as the fact that hundreds of thousands are good enough in the Catano decision, you know what the actual numbers are for AR-15s, things like this? We're talking well north of 20 million. 20 million in circulation around the United States today. And some estimates put magazines at north of 150 million. How does this court in the Seventh Circuit get around these rather inconvenient truths? Well, with their alternative facts. That's how they do it. They get around with the fact that they said, you know what, we've got our own test that's going to be looking at basically whether or not things fall on a spectrum from military grade to civilian grade. And you know what? We have decided that that's close enough to what the Supreme Court has done because we don't really trust any numbers. And as a result, bada bing, bada boom, everything's banned. It doesn't really matter how many tens of millions are in circulation. Good enough. There you go. Now, it's important to know the following. And before I do, if you just found us browsing through, be sure to hit that like, subscribe button. Make sure you don't miss any of our future content. Also, stick around to the very end where we have our ever popular quote of the day. Here's some important things to keep in mind. This is not the ultimate case decision here. What this is we're dealing with the injunctions and whether or not something's going to be enjoined. Keep in mind that when someone sues the government to try to stop a law from going into effect, they will most commonly try to enjoin that law from being enforced. In other words, put some sort of injunction here. There were 3 different lawsuits that were basically coalesced and merged into this one called Bevis versus City of Naperville as being kind of the frontliner case that's now in the Seventh Circuit Court of Appeals. We saw different decisions coming from different trial court judges. I've covered, I think, all of them on this channel over the past year. But just keep in mind, this is not the ultimate decision. Why are we talking about it then? Why is it so important? Because I know someone in the comment field is going to complain, why are you doing a video if there isn't a final case decision? The reason why is because by the time we get a common end-of-the-road case decision, the case was probably won much further upstream of that. The decision points about whether or not a case is going to be won or lost, you can usually find, or very often find, I should say, in a lot of these injunction issues. Why? Because the likelihood for prevailing at the end of the day is one of the key features that the court is deciding and testing. So if the court says, you know what, I'm not going to grant this injunction because I don't think you're going to win at the end of the day, if the court comes out and says that, that kind of is tipping the hand about where this is going. And the reverse is also true. If the court enjoins the law, does not allow it to go into effect and says, yeah, the plaintiff is going to succeed on this or has a high likelihood of succeeding on this, then again, it may not be the end of the game, but that's like putting up 50 points in the first quarter or something like that if this were, well, basically pick a sport with quarters, I guess. That's the reason why these sorts of things are very important. Another reason why this is very important is because it's very important for you folks, for everybody to understand the types of arguments that are being made by the parties and by the courts in this ongoing dialogue that's out there. Because a lot of times people just focus on the political talking points, but the legal talking points, which is what we're talking about here, are obviously what really moves the needle when we're talking about the courts. So I want you guys to understand how this all plays together. I did this breakdown much more thematically rather than categorically, where I normally walk through the whole decision. But I wanted just to kind of cut to the chase on this and show you, look, here's the crucial lens. This is the focal tipping point. And then they kind of weave everything through and they talk about law review articles and all this other kind of stuff. But if you want a deeper breakdown, let me know about that in the comment field below. I look forward to joining that discussion as well. I'm sure it will be an interesting one. I look forward to taking some friendly fire for people who inevitably confuse me as somehow supporting this decision. I hope some of you will put some fire back on those folks. Let's get to our quote of the day. This one comes from Greek philosopher Epictetus. Quote, "Wealth consists not in having great possessions, but in having few wants." Again, I appreciate you sticking around this long, and I will see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.